Got a question asking if a tenant, landlord and tenant, could include a provision in the lease that waive the right to handling tenants' personal belongings under the Civil Code. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, Civil Code Section 1953 governs a bunch of provisions. It's a protection, basically, to tenants that, generally speaking, in a lease or rental agreement, a tenant can't waive certain rights, okay? If you read subdivision A of Civil Code Section 1953, it basically says any provision of a lease or rental agreement of a dwelling by which a leasee agrees to modify or waive any of the following rights shall be void as contrary to public policy. And there's a list of 5 items. Rights or remedies under Section 1950.5, the security deposit statute, or Civil Code Section 1954, which is the right to entry. Any right to assert a cause of action against the landlord, it says leaseor in the Civil Code, which may arise in the future. Any rights to a notice or hearing required by law. Any procedural rights in litigation, and any action involving rights and obligations as a tenant, and then rights to have the landlord exercise a duty of care to prevent personal injury or personal property damage where that duty is imposed by law. Okay, so the requirements for a landlord sending notice to a tenant about abandoned, a property left behind after a tenant is vacated is contained at Civil Code Section 1983. I think 1984 has the actual form notice type deal. So the way I read that, I would treat that as basically a right to a notice or hearing as required by law. Basically, that it's just required. Okay, now nothing precludes under Civil Code Section 1953 from landlord and tenant, like at the end of their tenancy, they come to an agreement after the rental agreement is entered into to waive those rights. I would just exercise some caution though, because again, Civil Code Section 1953 is a protective type of law, basically. Okay, California is very consumer friendly based, basically. Waivers of personal property are generally accepted at the end of a tenancy. Basically, if a tenant is vacated or someone's given notice, that type of deal. If you do it like shortly thereafter when the lease or rental agreement is entered into, I think a landlord could be construed as, hey, although you entered the rental agreement in X, Y, and Z, and then shortly thereafter you did an addendum, hey, we can throw away your stuff, that could be construed as, hey, you had that term in the lease rental agreement. Okay, I just don't think it would go too well for you in court. And you got to be careful with some of these waivers, because again, I've seen leases that state that they waive, tenants waive jury trial rights, etc. That those aren't enforceable. There's also things too about the tenant will indemnify and hold harmless a landlord for personal injuries. That's not going to fly. Okay, just not working. So if your lease or rental agreement has these provisions in there, they're probably just not enforceable. Okay, so long story short, they're I have landlords all the time that say it's in the lease, well, it's against the law to have that, so no one's going to enforce it. So good thing, landlords, it's best to know what you can and can't have in your lease agreements. The Civil Code is pretty comprehensive about that, so just tread lightly is what I can tell you. Folks, if you're in the Northern California area and you need help with a difficult tenant situation, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.